evictions do tend to be relatively difficult. It's a common thing. And you speak to any eviction attorney that's a specialist in this field, and they'll tell you that evictions are sensitive. It's one of those applications or court actions that not infringe, but that impact human rights. And the right to housing has always been a very sensitive issue with, like, in South African history. So obviously trying to deal with evictions and eviction orders is just as sensitive. So us as attorneys need to be sensitive. The judges need to be sensitive. And what you often find is the judges are very apprehensive to grant orders without full consideration. Sometimes overly so, and sometimes just right. But as opposed to some other forms of court processes, we do find that these are like the hardest orders. This and criminal law, for example, are examples of legal processes that are very difficult. So in criminal law, for somebody to be convicted, it takes a lot for the magistrate to actually grant that order. And with evictions, it feels very similar. It feels very difficult. So an example that we had today, and I suppose this is just important for clients to have that expectation. The matter was perfectly fine up until this point in time. No one had said anything. No papers had been filed. And our experience today was the attendance of the occupier, and this was tenanted. So it was by way of a lease agreement, so not a hijacked building. So it shouldn't have been anything complicated. And the tenant attended court, and at court, she brought her child. So it was virtual, but she attended court. She was in the courtroom. And as she attended, obviously with the child, she made submissions that she didn't have any place to go, and she'd be rendered homeless. Now, for clients to understand, the problem with being rendered homeless is, in terms of PI, this is a consideration that the court needs to take into account. And it's further a consideration that the court expects the municipality to take into account. And this is sometimes where us and the clients have this disconnect, because from the client's perspective, absolutely makes sense. You're a landlord. There's a lease agreement. The person breached. They haven't paid. You're owner. You're also bleeding. You should be entitled to get your property back, and you've already waited so long. So it took us like a couple of months to get this thing before court, as it does. You have to file papers, you have to serve, you have to do the Section 42. It takes months to do. And even though he's now patiently waited all this time, to hear now a judge say, well, unfortunately, we cannot grant the order. We expect further information from the municipality. This is the first submission the tenant has made that she's going to be rendered homeless. The court isn't comfortable granting this order, especially with a child, and it's a household headed by a woman. So these are considerations needs to take into account, and the court postponed the matter. And unfortunately, the reality is the date that the registrar gave us is somewhere in August. And that is unfortunately where we are. We have to go to the municipality. We have to get them to update the report, and submit it again to court, serve it on the occupier, and take it from there. So it is unfortunately a reality. Not all evictions play out like that. And I mean, Nick, I think you'll agree. So 70% of the time, especially with tenanted evictions, tenants have no interest in going to court. So they fail to pay once or twice, but they're okay with that. As soon as you serve that application, they're out of the property. Sometimes they disappear overnight. So you find that 70%, that's the case. But unfortunately, in this specific instance, the client thought, oh, great, we get the order sheet, move out. And, maybe 10% of the time it gets to a point of difficulty where, it gets postponed, and you need to jump over more hurdles. But Nick, from your side, do you want to take the eviction problems from a different angle?
Yeah, so I think it's important. One of the difficulties with the job that we do, and especially bringing eviction applications, is obviously it's in the best interest of the attorney to try and break down the eviction process as simply as possible. I know each of our respective officers have different ways of doing that, to try and break down and simplify what is a fairly complex process in legal terms, compared to a lot of other processes. And that's as a result of us having, PI, which affords the tenant some extra protections which we need to go through. But what needs to be remembered at the end of the day is, there's a judge that's sitting on the other side of this, and he's the one who's got to pronounce at the end of the day. And as much as we can demonstrate, well, this is the exact process that goes on. A judge has got to make a call, and a judge is a human at the end of the day, and things do come up, and judges do make decisions which they believe are in the interests of the court. Even if you have all of your ducks in a row and you've ticked off all the tick boxes, that's, I think, what you experience today is, you're sitting there, you're at the end, and you've done everything that's required to get your order at the end of the day. And unfortunately, there's a new factor which has to be taken into account just because that is the way the court interprets it in the circumstances. That's not to say that the court is wrong in any way. That is the job of the court to look at all of the prevailing circumstances, and especially in light of the requirements of PI, to ensure that any of the factors which are prevalent in a particular matter are actually looked at in full by the court before it makes its ruling. And one of the important things here is especially from my side, is when you're addressing a tenant, when you're talking to a tenant, just make sure that you are keeping yourself, all of your correspondences with the tenant in ducks in a row. So I was speaking to Bruno earlier, and one of the experiences that I'm having this week is a matter where an eviction has been brought in the High Court. It was in fact granted, and subsequently the tenant has brought a rescission of judgment application. Okay. And they seek to have the order which was granted by the court set aside because it was granted in their absence. Okay. The basis is generally that the tenant says that there was certain verbal assurances which were made to the tenants during the time that the eviction had been brought, that the matter would not be persisted with, okay, or pursued to finality, and the parties would essentially come to some sort of settlement agreement outside of the attorneys which were being used in the particular matter. Now, the problematic part of this is obviously the assertion is from the tenant that this has been done verbally, and so there's absolutely no written correspondence or evidence that can be placed in front of the court to substantiate this sort of argument from the tenant. And the scary part about something like this is, in those circumstances, in the same light that Bruno's had difficulties, there are difficulties in such a case where a rescission of judgment comes along, because again, the judges are there to make sure that all of the issues are fleshed out to their fullest degree, and that they don't close the door to anyone who might have redress in court if a matter is fully ventilated. So be very careful. We know as attorneys that clients would like to use their attorneys as little as possible, because it means at the end of the day, you've got a little bit of a less of a bill coming your way. But please be very careful in your correspondences with tenants. Please make sure that if you are corresponding with them, you do have a written record. Try write or email as much as possible, just to make sure that you have clarified any of your positions that you correspond with the attorney and or with your tenant rather. And especially if you are in doubt as to something that needs to be said, some correspondence that needs to go to the attorney or to your tenant, make sure you use your attorney so that you don't prejudice your case at the end of the day. It will save you a lot of time and money if you get it right the first time and it doesn't come back at the end. That's not to say that rescission of judgments don't happen where you've been perfectly in line, but at least protect yourselves a little bit. It can save you a lot of heartache in the long run, I think.
Absolutely. And I mean, I recall, and I mean, you've probably had this countless times. I recall having cases where you go through the effort, you're on the verge of eviction order, or you've got an eviction order, and unfortunately the landlord takes something into their own hands and they almost renew the occupation. Yeah. They enter into a form of an agreement where the tenant goes, well, it's a new lease agreement, so that previous eviction order is now moot because it doesn't apply. I'm now staying here on a new basis. And I've had cases where you've had to restart the entire eviction process. Yeah,
100%. And especially we've even had circumstances where, for instance, there's an ejectment which is done. A court order where an ejectment order is granted, and then some other level of rights of occupation is given subsequent to the ejectment.
Yeah.
And it is as harsh as your magistrate or your judge will say, but this is something new. Restart the process again. You can't use your old order. That's an absolutely, a breakage, process. You really don't want to get yourself there.
And I suppose the difficulty is, you know what, like I can't fault the landlord sometimes for even being kind, because a lot of those gestures that I've experienced is pure kindness, where the landlord thought that they were just, doing this person a favor. But bear in mind that your attorney is there to represent you. So we are not anti-kind. If you give us instructions and go, I want to be kind to this person, give him more time, we can do that. We just know how to do it so that it doesn't impact the executability of the order. And I suppose that's the key to it, is you can get, there's multiple ways of skinning a cat. The difference is the attorneys do it in a way that doesn't hurt you if something goes wrong and you need to go forward. And I mean, just open communication. We've had clients that in the middle of an eviction process passed transfer to somebody else. And once the tenant got wind of this, the entire eviction application collapsed because of ownership issues. So it's just like keep that open communication. Remember, as soon as your attorney's on it, you need to actually be able to engage. If you're not engaging with the attorney, something could go wrong quite drastically.
Yeah, 100%. 100%.
Cool.